What up? What up? We just get everything set up here and we can jump into it. Just wanted to go live quick and go over this brand new filing. This is something that was highly anticipated. This thing is 186 pages, so there's no way we go through the entire thing. But I would love if some of you pulled it up too, and we can see if we can pull anything interesting from this thing live on stream. I'm just gonna kind of skip around, go through it, see if we can find anything interesting. But yeah, let's see what we can take from this. God, if you're on X, make sure to share this stream. Would love to get more people in here. And if you're on YouTube, make sure to drop the stream a like. We got Keith in the house, Dirt Nap, John. Keith called the pump earlier. That's a fact. He might be the one who pumped XRP. So Ash, good to see you. Della, good to see you. 3:20 a.m. where you are. Yeah, it's pretty late where I am too, but figured we'd jump in, do a quick look at this thing, see if we can find anything interesting. So I said this before, right? If you're sitting at a computer or something and you want to pull this open and drop me any page numbers I should check out as we go through this, I would really appreciate that, because this thing's 186 pages. So I'm going to be counting on you guys a bit to help me find anything interesting in here. Other than that, I'm just going to kind of go through and go through this thing with you and see if we can find anything interesting. This is I'll do a little bit of an introduction to what this is. The SEC says Ripple owes them $2 billion for their sales of XRP as a security. The SEC essentially only got Ripple with $700 million worth of charges, but they want $2 billion. We're not going to get into how the SEC got to that number because it's a bit ridiculous. But what we expect to see in this document is Ripple, one, arguing that investors are not at a loss. Two, Ripple likely changed the way they sold XRP to get around what the SEC is complaining about. And then three, the possibility that some of these sales didn't happen in the United States. So those are the main things we're kind of gonna be focusing on here. And I see we're really popping off on YouTube early here. We already got 317 in here, which is incredible. Guys, if you're over on YouTube, make sure to drop a like on the stream. Upper right hand corner is going to be 3 dots that allow you to do that. And on X, it's going to be just a retweet would really help. Let me see. There's a good comment here. Only programmatic sales. Yeah, these are only the sales to institutions, right? Not all of Ripple's sales of XRP were deemed securities. It was only a subset. So this is fighting about the subset and what Ripple's punishment is going to be from the SEC. Let's see what we got here. The remedies in this case should reflect its facts. Ripple's a 12-year-old financial technology company that has played a key role in developing innovative technologies that use the open source XRP ledger blockchain. So a little history of Ripple itself. Its on-demand liquidity ODL service generates real value by making cross-border payments faster, more transparent, more cost-effective. This court has ruled that Ripple violated Section 5 of the Securities Act, a strict liability statute, by offering certain sophisticated investors investment contracts related to the digital asset XRP. So right here, Ripple is essentially acknowledging that the court ruled that some of its sales of XRP was securities. Ripple has publicly acknowledged that the ruling... Okay, so Ripple has publicly acknowledged that the ruling, and does again now. So Ripple saying they agree with it and says it has changed the way it sells XRP and changed its contracts to avoid problems identified by this court. So this is kind of funny because John, thank you. Tracy, thank you. No, Tracy, no settlement. Not yet. So this is pretty funny. Ripple saying, okay, look, the SEC got what they wanted. Certain subsets of our sales were securities. So what did we do? We changed the way we sold XRP to these institutions, so it's no longer securities. And this is one of the things I've been saying on this channel, right? Ripple's a very nimble company. They can structure their sales any way they want. The SEC was only able to pigeonhole them into a corner on a certain subset of their sales, but Ripple can very easily sell to the same institutions in a different way and not violate the terms of the court. So that's the issue the SEC has here. They can only pin down Ripple on very specific things they did in the past, but trying to create any kind of laws going forward that are going to restrict what Ripple's doing is never going to happen. So So this is pretty funny. Ripple's just saying, okay, we changed it. So what's the SEC's problem? It has ensured that its counterparties qualify as accredited investors, and its subsidiaries have obtained licenses to sell XRP as a digital currency outside the United States under the provisions of regulators who do not treat XRP sales as securities. Those appropriate responses to this court's ruling provide reasonable assurance that the violation will not reoccur. So Ripple's right here is just saying, look, we're going to sell XRP in the same way we're already doing to institutions not in the United States, and the ones in the United States will just sell it differently. Which is so funny because the SEC has gone on this entire battle to try to stop Ripple from selling XRP, but they can't really do anything because Ripple's just going to sell it in a different way or just not sell it in the United States. So right off the bat, this is probably infuriating if you're the SEC. Ripple's literally just saying, all right, well, you can't do anything about it, so we're going to keep going here. So solid first paragraph here. I have to say this is kind of comical that the SEC went through millions of dollars of taxpayer money and years of lawsuits just for Ripple to say, okay, we're going to sell outside the United States. We're going to sell it to institutions in a different way. Some funny comments in the chat right now. Some of them I can't read, but I still think they're funny. The SEC's remedial requests are more evidence of the administrative overreach that has been beset this case. The agency acts as though it had prevailed entirely and had proved reckless conduct. It has done neither. The court ruled that most of Ripple's pre-complaint XRP sales were lawful. When it brought this action, the SEC did not even allege that Ripple itself acted recklessly. It did make such allegations against Ripple's chairman and CEO, but abandoned any attempt to prove them to a fact finder. Yet the agency now urges this court to find Ripple reckless at the penalty stage and to issue an injunction based on the mere speculation that Ripple may break the law in the future. The agency has also seeks reckless disgorgement barred by controlling Supreme Court and circuit precedent, and a separate penalty that exceeds more than 20 times what it obtained from any other defendant and respondent in a digital asset case. Wow, this is brutal. This is absolutely brutal. Like, I'm reading this laughing because it's almost comical the way Ripple's written this. It just makes the whole thing seem so ridiculous. So let's break this down real quick. So the SEC has to prove that Ripple's been reckless in their sales of XRP for essentially the SEC to get any money. But the agency itself, the SEC, never accused Ripple of being reckless. The SEC is now saying that they're worried that Ripple's going to be reckless in the future, but they never even accused Ripple based on the 14 years of them being a company of being reckless. So it's just hard to imagine the SEC's gonna do much when these facts are this brutal against you. There's another funny one in here. The only time the SEC did make allegations that anyone in this case was reckless was Brad Garlinghouse and Chris Larson, but then they had to give up on that case because it was so bad. So the only time the SEC ever made any allegations at this point that would have stuck in terms of Ripple paying a penalty were against Brad and Chris, but those allegations were so weak the SEC had to drop them. This last sentence is pretty funny too. It's just making fun of the fact that the SEC is asking for 20 times more than any other case we've ever seen. So a lot of just hard-hitting bad facts against the SEC in this opening paragraph. And, I really like the way Ripple kind of is putting this in a way it's in layman's, right? Like, I'm not a lawyer. Some of these words I've never seen before, but it's very easy for me to read through this and be like, what is going on at the SEC? This is a tough paragraph to read for anyone if you're even just walking into this case. Some Michael saying 0 penalty. Brad just posted. Should we take a look at what Brad says? Let's take a look at what Brad says real quick. Guys, also really appreciate you guys ever dropping any information in the chat. Like what Brad says. Those are good things for us to go over. So let's see what Brad said. Brad just made a post. Yeah, this is good. Feels appropriate that we file a response on the same day that 2 SEC lawyers resign for their misconduct in the debt box case. The U.S. will be picking up the pieces of this agency's disastrous policies long after Gensler is gone. So pretty well said by Brad. He's poking fun at the fact that the SEC just had to fire 2 different lawyers because their conduct is so egregious, and obviously pointing out the long-term implications of what we're seeing at the SEC. This is those things that tell me that there's no settlement going on right now, because Ripple and Brad Garlinghouse are just chirping the SEC blatantly on Twitter. Let's see what else we got in the chat. Anything interesting? I would agree, 0 penalty. I do think there will be a penalty. Okay, I'm going to go through a couple. We'll switch over to X real quick and take a look at some of these posts being made by the executives, and then we'll go back over to the court case because they might be pointing out something. Stuart Alderati said, our opposition to the SEC's request for $2 billion penalties for legacy institutional sales is now public. In a case that had no allegation or finding of recklessness or fraud, in which Ripple won significant issues, the SEC asked is just more evidence of its ongoing intimidation against all of crypto in the United States. We will remain confident that the judge will approach these final remedies phase fairly. Yeah, great comment. This is kind of what we were reading in the opening brief, right? The SEC has to prove that Ripple acted recklessly and egregiously against the law, but the SEC never actually alleged that in the case. So, look, the SEC is asking for the court to make up an allegation against Ripple, right? The SEC didn't have the what to actually charge Ripple with fraud, but they want the court to come out and declare Ripple of committing fraud. So it just shows how poorly this case was orchestrated. The SEC is kind of now litigating things that they didn't even bring to the case. They're hoping the judge is going to do the hard work for them. And I just think that's entirely unrealistic. So this is a good tweet by Stuart Alderati. Nothing too hard hitting. I remember someone said something about Jeremy Hogan. So let's take a look at what Jeremy Hogan said. Also, guys, if you're on YouTube, we're putting up awesome numbers on YouTube right now. We're close to 700 people. Go to that upper right-hand corner, drop a like on the stream. It's going to be really, really helpful in helping more people see the stream. And also, if you're new here, would love to have you more often. Make sure to sub to the channel. Not seeing anything by Jeremy Hogan. I was kind of surprised he would have tweeted that fast. Stuart Alderati. Okay, so James K. finally didn't say anything else. So I think the best tweet we have right now is Brad Garlinghouse just poking fun at the fact that obviously this happened on the same day that 2 SEC attorneys were fired. All right, I'm gonna check the feed real quick and see if we have any good breakdowns. Oh, here, this is cool. Ripple's showing off their board to the chair just to show them that this is a very seasoned and professional board. Sandy O'Connor, former JP Morgan, Anya and Manuel. Let's see, co-founder and partner of, I don't even know these places. Warren Jensen, CFO of Amazon, Delta Airlines. Someone from SBI, Rosie Rios, of course, former Treasury Reserve. Michael Warren served in the administration under 2 presidents. Ashish Birla. Okay, so Ripple just showing off their firepower. I'm going to check one more time to see if we don't see what any professionals are saying about this. See what else we got. Sean said, I don't think there can be a penalty. The court above Torres, the Second Circuit, specifically stated the SEC must show loss of money. If they cannot show, they cannot collect anything, 0. Yeah, I agree with you. Sean. I don't think the SEC should get anything. I still do believe there might be a transaction or 2 that fall within the court's ruling. I think there's a possibility that the judge might issue some kind of fine. I just have a hard time seeing the SEC walking away with 0 here. I mean, who knows? Maybe they do, and that would be the ultimate slap in the face. But typically, what we've seen is, and what I've noticed is, a lot of XRP investors will get or holders will get very confident and think that Ripple's going to win on every single issue, even though I think they should. Ultimately, the court has handed the SEC some small wins. So I think the SEC will get a small win. Hold on, let me just check out this, then we'll get back to the court filing. Ripple could also lawfully sign other contracts for institutional sales by registering those particular contracts as securities, by taking advantage of an application exemption, or by ensuring that all transactions are extraterrestrial and permitted under ongoing government law. Ripple affiliate entities are currently pursuing more financial service registrations and licenses applications where they're seeking to do business. Okay, so this is pretty funny too, right? Is my stream down on X? I'm getting a notification that my stream's down on X. Let me check it out real quick. Looks like I'm back. Whatever. This is pretty funny. Ripple's literally saying, like, look, nothing we were doing was illegal. They're just saying we should have registered some sales with the SEC. So if this is really that big of an issue, we'll just register the sales with the SEC under an exemption and move forward. So what you're seeing is that Ripple has a lot of different ways to kind of come back at this and say, okay, look, it's kind of ridiculous that we would owe you any amount of money you're claiming. Sorry guys, my computer's being a little laggy right now, but let's get over to the filing again. Let's see, where were we? Okay. This court ruling has provided welcome clarity and guidance about the ways in which Ripple can lawfully distribute XRP. Ripple has every intent of adhering to the guidance in the future and every incentive to do so. The SEC's draconian remedial requests are ungrounded in law or principle. The court should reject them in their entirety. Okay, so Ripple's saying right here, and I think this is important. Some people have speculated for a while that Ripple would appeal this court case to try to get all contracts or make it so that they could sell XRP in the way they were doing before. And this is always something I'd push back against. I never thought the SEC was ever going to, or I didn't think Ripple was ever going to appeal this ruling. I always thought that Ripple could just sell XRP in a different way and essentially get rid of the issue. So this is something that I've speculated on, that Ripple was going to be perfectly fine adhering to whatever the court said, because Ripple can just change the way they sell XRP. Like, it's not that hard. Ripple's a very nimble company. They can offer these contracts however they want. So this is good. This is Ripple saying, look, we're fine with the court's ruling. This court ruling is helpful, and we're going to move forward with it. One other thing someone said, okay, so apparently Ripple, this is a good comment. Really appreciate anyone dropping any tidbits they find. Obviously, I'm going slow through this. I'm going to be breaking things down, and we're going to be looking at a lot of what different lawyers are saying on X, because those are the experts, guys. I'm not a lawyer. I'm just giving you my opinion on some of this stuff. Steve said Ripple asked the court for no more than $10 million. Yeah, so Ripple's saying, look, we'll pay a fine, but we're not going to pay $2 billion, right? I think Ripple understands, like, whatever, like, you get through the process, you pay a fine, you get your slap on the wrist, you move on. So Ripple's saying, look, 10 million, not $2 billion. Someone's saying that James K. Filan is saying something. We'll take a look at see if he is. If not, we'll get back to reading. A lot of what we're going to be looking for, guys, is other people putting out posts in regards to what we're seeing, just because a lot of the lawyers are going to have really in-depth opinions on this stuff. I don't see anyone saying, I don't see anything from James K. Filan. So other than this original document, which we're going through. Okay, let's go back. All right, this is where it's going to get a little dense, because this is prior case law. So let's see if we can find anything interesting in here. Yeah, this is back to an important thing. Ripple saying it has changed the way it sells XRP and changed its contracts to avoid future violation. So Ripple right here is just saying, look, we're doing things in a different way that are compliant now. And this is a huge hit to what the SEC is saying. I want you guys to understand that Ripple can still sell to U.S. institutions as long as they do it in ways that they didn't get hit with in the court case. So this is a big issue for the SEC because they can only litigate based on the past. They can only tell Ripple they're not allowed to do what they were doing before. They can't tell Ripple that they can't do these things in the future. So this is a big issue for the SEC, and it's going to be really easy for Ripple to kind of move forward and just say, look, we're doing things differently now. Everything we're doing is compliant. Let's see. The SEC's argument that Ripple should be enjoined rests on unsupported conditions and has not accepted. Yet the SEC would hardly say that its own complaint recklessly disregarded the law, even though the court has rejected this agency's position on programmatic sales and other distributions, just as it has rejected Ripple's position on institutional sales. So very interesting. I'm just reading this in like layman's terms. It seems like Ripple's trying very hard to show the court that like, hey, we're not saying that we're not going to agree with what the court said. Ripple's making it very clear we're going to abide by what the court has said. Which I think is good, right? It's Ripple showing like, look, we're not asking for any special rules. We're not asking for any special treatment here. We're going to follow what you say. But it's insane that the SEC is essentially trying to get you to charge us with fraud when there was no allegation of fraud. This is maybe when Ripple was founded in 2012, there was widespread uncertainty about how the law would apply to digital assets. In 2014, a GAO report to Congress on virtual currencies said that federal agencies responsible with respect to virtual currencies were still being clarified and cited XRP, prominent example of a decentralized virtual currency. That report, on which the SEC commented, discusses the SEC's jurisdiction over virtual currency related securities, but did not suggest Ripple or any other digital asset company was selling investment contracts. Wow. So this is pretty good right here. In 2014, Congress released a statement saying that, there's these new things out here called cryptocurrencies. We don't know what they are. There's one of them called XRP. These things are decentralized virtual currencies. And right now, that's all we know. And the SEC took a look at it and says, okay, well, also in this asset class, there could be virtual currency related securities, which makes sense, right? I mean, no one's going to pretend like there's not securities out there. But the SEC never said in this document that they thought XRP was a security or that Ripple was issuing securities. So what this shows is the SEC saw XRP very early on and clearly didn't have any serious issue with what was going on there. What's up, Ed? Good to see you, man. We're just going through Ripple's new filing. The SEC is getting hit pretty hard here, Ed. Things are looking really, really solid, but nice to have you on board. Darren Naples, that's a great comment. Everyone take a look at what Darren just said. He said, just donated to John Deaton. Everyone give anything you can. And guys, I say this all the time. Even if you can't give anything, just give him a retweet, man. It's so easy to go to his account and just retweet some stuff. Just, there's very little that isn't going to help John Deaton in a big way. 1 second, guys. I gotta hydrate. All right, let's see. Ripple has sought advice from respected law firms on how to comply with applicable laws when selling XRP. One of them in 2012 said there was a lack of applicable case law. Nevertheless, suggested steps Ripple could take to avoid running afoul of federal securities laws and other laws governing payment transactions. Ripple took these steps. 3 years later, another firm advised that XRP does not appear to be a security under the Howey test and is unlikely to be deemed a security under federal law. The firm noted that the SEC has not taken a public position on whether virtual currencies are securities within the meaning of federal securities law, but observed that the treatment to date suggests that the SEC's virtual currencies as no more akin to commodities and securities. So Ripple's just saying, look, in the early days, everyone made it look like these things weren't securities. The SEC wasn't saying anything. The SEC knew about XRP. They weren't saying anything. So everything we saw made it seem like this wasn't going to happen. And then later, the SEC comes around with this case. So Ripple's just pointing out the absurdity of the SEC obviously watching XRP throughout its entire history, never saying anything, and then deciding to slap Ripple with this case. And I think the most egregious part now is that now the SEC is trying to say that Ripple acted unlawfully and Ripple acted with like blatant disregard for the law, I guess is a good way to say it. Well, obviously they didn't, because they did everything they can to try to make sure they were following the law. So it's just so funny that Ripple's hiring lawyers to make sure they're following the laws as closely to a T as possible. And the SEC decides, okay, good, let's sue them and say they're not following the law or blatantly not following the law. And then let's not sue all the cryptocurrency companies that are committing pump and dumps and scams. Let's let those run rampant in the industry. So I think it's actually a strategy by the SEC. They want to try to delegitimize the good players and try to legitimize the bad players, try to make this industry look like a massive scam. It's unfortunate, but that's apparently the SEC we're dealing with. I want to look at some more of this ODL stuff. Ripple voluntarily gave the SEC information about its business in 2013. Interesting there. Years before the agency first suggested an inquiry of Ripple's conduct in 2018. So this is interesting. Ripple showed the SEC their business in 2013. The first time the SEC started getting suspicious was 2018. In 2019, Ripple voluntarily halted nearly all XRP sales, attempting to cooperate with the SEC and reach an agreement. Okay. In 2020, Ripple began making ODL sales in which it sells XRP to be used as a bridge currency in cross-border transactions. Before those sales, Ripple disclosed to the SEC its intent to do so. Ripple had an objectively reasonable basis to believe that ODL sales were not investment contracts. Ripple's counterparties, ODL buyers, hold XRP so briefly they cannot reasonably expect to profit from any increase in the value of Ripple's ODL agreements, prevent them from doing so. So, Ripple saying in a bunch of ways here that, look, we tried to follow the law. The SEC wouldn't tell us if we were following or breaking the law, and now they want to come and tell us everything we were doing was illegal. Ripple's interactions with other regulators further shows its responsible attempts to follow the law. In 2013, Ripple registered its main XRP selling subsidiary as a money service business with the U.S. Treasury Financial Crimes Enforcement Unit, FinCEN. In 2015, Ripple subsidiary applied for a virtual currency licenses in New York Department of Financial Services, a BIT license. Just 2 months after the BIT license regulatory regime was created, it became the fourth company to receive a BIT license and the first license for an institutional use case for a digital asset. As of today, that subsidiary is licensed as a money transmitter in 37 U.S. states and territories, with 8 more applications pending. Okay. So Ripple's just saying here the obvious fact that, look, you're saying we were recklessly breaking the law. You're saying that we were doing all this stuff recklessly and that we should be charged with a massive fine. Meanwhile, we're like working with all the regulators in the United States to try to make sure we're doing this as compliantly as possible. So right now we've really seen this thing focused so far on Ripple just saying, how are we supposed to be paying a fine for being reckless when everything we've done in our history as a company was try to be as responsible as possible? Ripple's reasonable basis to believe that sales in the United States were not sales of securities was also supported by regulatory actions in other major foreign jurisdictions. For example, in 2019, Japanese law recognized XRP as a virtual currency, not as a security. By mid-2020, Singaporean law recognized XRP as a digital token that could be used as part of a digital payment token service. Ripple's ODL sales after the court ruling do not show disregard for the law. Ripple has taken measures since this could be interesting. Ripple has taken measures since the court's ruling to avoid future violations of securities laws. First, Ripple's sales of XRP under contract signed since the ruling have been limited to ODL sales. Let me just see these footnotes real quick. Okay, nothing too interesting. ODL is a software product used to inherit ODL is a software product that uses the inherent properties of XRP. Fast settlement, low transaction costs, settles customers' cross-border transactions in nearly real time. ODL is much faster than the traditional cross-border payments method and works with traditional payment systems like banks. And works when traditional payment services like banks are closed. The XRP used in ODL transactions acts as a bridge currency between two fiat currencies. For example, an ODL buyer who wants to exchange euros for Australian dollars purchases XRP with euros and sells XRP for Australian dollars, converting one fiat currency to another almost instantaneously. ODL buyers are mostly licensed financial institutions such as remittance companies. Okay, so Ripple just breaking down ODL. ODL buyers hold purchase XRP for seconds. Ripple's ODL contracts protects buyers from losses and prevents them from earning profits due to even monetary volatility in the price of XRP. Momentary volatility in the price of XRP. They buy XRP solely for the use of ODL transactions. ODL contracts do not contain provisions that this court has found show an intent to invest, such as lockup periods, resale restrictions, and discounts. Okay, so Ripple is saying, look, if we sell XRP directly to an institution purely for ODL and we don't have anything about a lockup period, resale restriction, or discounts, then it can't be a security. So this is a really interesting statement right here. This lets us know what Ripple's essentially not allowed to do when they're selling XRP. They're not allowed to put any restrictions on that XRP, right? The institution just has to use it how the institution wants to use it. Ripple can't be telling the institution, hey, you have to lock it up for this period of time and do all these other things because that makes it an investment contract. Okay, so Jeremy Hogan just tweeted that the SEC squandered its opportunity with this first brief, and he hasn't commented really on this current brief, but he just thinks the SEC did a terrible job with their brief, which is always good news, right? If the SEC is putting forth a crappy brief, then it's going to be easy for Ripple to smack them down. Guys, we have almost 800 people from YouTube right now. That's absolutely incredible. If you are over here from YouTube, just make sure to drop a like on the stream. Upper right-hand corner, there should be 3 dots to make that nice and easy for you. And it's going to help more people who don't see the channel typically, or maybe don't even know about XRP, kind of get involved and start learning about it. So I would really appreciate any help there. And if you're on X, a simple retweet goes a long way. Let's keep going. So let's just wrap up what's different about Ripple's ODL transactions now, because now we're actually starting to learn some stuff, right? Now we're actually starting to learn how Ripple can do ODL in the future. No lockups, no pre-sales, no discounts. So Ripple just has to transfer these institutions XRP directly, which realistically, I think we're all happy about this, right? Like I'd rather have Ripple selling XRP for full price. So that's cool. Second, most of Ripple's ODL business is outside the United States, primarily between its Singapore subsidiary and foreign counterparties. Ripple's Singaporean contracts are made by a Singaporean subsidiary and governed by Singapore law. They are supervised by a Singaporean regulator, which has licensed Ripple subsidiaries to sell XRP to ODL customers. Ripple's remaining ODL business in the United States uses non-XRP bridge currency. Oh, that's interesting. Ripple's remaining ODL business in the United States uses non-XRP bridge currency. Very interesting there. Okay, this is interesting. So it seems like Ripple has some product in the United States not using XRP as the bridge currency. So I wonder if Ripple's using some other digital asset here. This is really interesting here. I wonder what Ripple's doing in the United States. I don't see. Yeah, DirtNap, you caught up on the same thing. So Ripple's apparently got something they're running in the United States. I wouldn't be surprised if it's Bitcoin. I would not be surprised if it's Bitcoin. Bitcoin has a ton of liquidity in it. Bitcoin would work very well for Ripple's ODL business. I don't like people are going to take this the wrong way. People are going to think this means that XRP is going to be used. Not at all. I think Ripple would much rather be using XRP than Bitcoin. But this is interesting because it really shows that Ripple's got some other options. I don't think they would use XLM or HBAR just because XLM and HBAR don't have the same liquidity. Bitcoin's got the best liquidity. Bitcoin's going to be slow. It's going to be yeah, Bitcoin would work for ODL because because it would just make the ODL transactions like 20 minutes long. Still better than the normal financial system. Like obviously we'd rather have transactions that take seconds. Well, the reason why I say Bitcoin is the most regulatory compliant. Anything else is just going to make new issues with the SEC. Well, Josh, it doesn't have to. Look, if Ripple has to run their business different in the United States, then look, it says Ripple's remaining ODL business in the United States uses a non-XRP bridge currency. And the footnote doesn't tell us here. So I'm sure we're going to see more people asking about this and maybe even says something. So let's just keep reading for now. This is interesting. Even if Ripple's ODL contracts otherwise met this court's criteria for investment contracts, which they do not, those foreign contracts would not violate U.S. securities laws. Okay, so this is the other part that we were talking about. I'm not going to go through this entire paragraph. One, Ripple's saying we sell XRP differently now, so we don't sell XRP the way the court told us not to. Two, most of our sales aren't even in the United States, so we don't know what the SEC is talking about, right? Like the SEC is saying that they have jurisdiction over these sales of XRP, but we're not even selling it in the United States. So how does that even make any sense? So another great point by Ripple. Let's go over this third point. Since the court's decision, Ripple has ensured that all new ODL customers have at least $5 million in total assets. To be clear, Ripple is not selling and does not intend to sell to ODL buyers. Nevertheless, okay, so Ripple's just saying, look, if we are selling XRP, we also make sure they're accredited investors. To me, that's kind of a non-important point. Ripple has not distributed since at least 2016. The brochures that this court found gave rise to expectation of profit. It is communicated that all necessary Ripple officers, advisors. Okay, and then I guess Ripple was doing something with the brochures that the court didn't like. Let's see. The SEC should have to pay Ripple. Yeah, the SEC should have to pay Ripple. Ripple has long said they have a fiat-to-fiat portion of their software that does not use. No, I know they have a fiat-to-fiat version, but they specifically say in this paragraph that they have a non-XRP bridge currency. So that doesn't sound like to me fiat to fiat. That sounds like to me they have another bridge currency they're using. And like I said again, I don't want people to think like that means like Ripple's abandoning XRP or anything like that. Like Ripple's fighting this case purely for XRP. If they had another bridge currency that worked better than XRP, they wouldn't be in this case. They would have just said, screw it, we're using something else. So it just means that Ripple obviously figured out another way to get around what the SEC was saying. Brad is a rock star. I agree. I love Brad. I wonder if other crypto codes are helping with XRP fighting the SEC. Let's remember, if XRP loses, then the SEC will come after all remaining crypto projects, including Ethereum. To be honest, I don't know if Ripple honestly really needs to help. Josh, that's funny. Look, I don't know if Ripple really needs to help. I'm sure there are people who offered up their support, maybe offered up donations to help fund the fight. But look, Ripple has the best lawyers around. Ripple has the best funding to fight the SEC. I don't know if they really need anything. Could they be referencing their stablecoin DirtNap? That's not live yet. My guess is Bitcoin. My guess is Bitcoin. I guess technically it could be Ethereum, maybe XLM. But look, Ripple needs to pick the thing with the most clarity. It could be. I don't know. XRP Fudster is going to jump all over that one. Zach, what's your guess? I would love to hear your guess, and awesome to see you here, Zach. Zach, I hope you get the channel back, man. I went through the same exact thing, so if you want any tips on what I had to do, just let me know. I remember, Zach, me and you were actually live. It was one of our first times going live together. I think we were doing a Twitter space, and my channel got taken down. So don't worry, you'll definitely get it back. Make sure to hit me up if you need any help. Let's see what else we got here. The SEC asserts that ongoing ODL sales are akin to institutional sales. In any event, the SEC's assertion is inaccurate because Ripple's ongoing sales have the key. Okay, so this is a little bit repetitive of the same stuff. Let's see if we can get to something else interesting. The SEC fails to show that the injunction is needed. Okay, I don't really want to read about an injunction. Ripple is not a securities industry participant. It does not sell securities. Yeah, just more reconfirmation that XRP is not a security. So this is important. The SEC tries to cite library, and Ripple just says, look, the different facts and circumstances. Bitcoin Lightning. Is that the actual Jungle Inc? I think probably. The thing is they said they use a bridge currency. They said they use a bridge currency in their ODL software. So I think it's a digital asset. The specific quote we're talking about here is that Ripple uses a non-XRP bridge currency for ODL. Ray Ramirez, man, thank you. I appreciate that so much. Ray says, thank you, Mikkel. I appreciate you coming live to walk us through this file. Absolutely no problem. And I really appreciate the support for the channel. Ray's been a member for 2 months. Let's go, Ray. Thank you for the support. Absolutely amazing. USDC as ODL. USDC is a good choice. Zach says USDC or Bitcoin. I think USDC is something I wasn't thinking about. Could be USDC. Good guess. I like that. Let's see what else we got here. Okay, this could be interesting. Ripple's mere ownership of XRP is irrelevant. The SEC that Ripple is incentivized to violate Section 5 because it's still holding the largest amount of XRP by any person. The court decision leaves clear avenues for Ripple to sell XRP and distribute XRP lawfully. Ripple's ongoing ODL sales respect the lines the court has drawn by avoiding lockup provisions, resale restrictions, or discounts, and by preventing ODL buyers from earning profits or taking losses from the exchange of XRP. Ripple can make programmatic sales extraterrestrially and use exemptions. It can make any kinds of these distributions, such as grants, compensation for services. It has no incentive to expose itself to liability through future violations. Okay, so this is awesome, guys. This is just once again Ripple saying, look, we won't sell XRP in the ways the court said, but the court also said we can keep selling XRP, so we're going to keep selling XRP. It's so funny to see Ripple just simply coming out and saying, look, we're fine with what the court ruled. We got no issues with it. It's the SEC here who's suddenly trying to make the court change everything they put out there. Taco Tuesday said it would have to have regulatory clarity already, or you open a new case. Spend a bit on the XRP ledger saves all the time and money versus Lightning. Yeah, I agree. Spend a bits is an awesome option. I do think it's a digital asset with clarity, though. That's why my guess was kind of Bitcoin. I know some people don't think Bitcoin has clarity, but oh, that's good. I like this comment. They were probably using USDC and now see the type of volume to tap, which leads to them creating their own stablecoin. Maybe. No, I don't think this is the reason XRP is not in Liquidity Hub. I have a feeling it has to do with the fear of selling XRP to institutional investors. I think Ripple's just going to wait until the case is over, to be honest with you. Ripple needs to make sure. Ripple's going very, very far out of their way here to show the court that Ripple's doing everything in its power to comply with the rules. Ripple doesn't want to do anything that makes the court think, hey, we're just kind of going to do what we want here and ignore your ruling. So it's very clear to me that Ripple has been being very cautious with what they've been doing since this court case ended. Theft for Life says Mikkel, clarity is not the issue. Bitcoin takes too long for ODL. Well, no, because they could just make ODL take longer. Like most financial institutions are used to their payments taking a day to 3 days. So if they can still settle their payment in 20 minutes with Bitcoin, it's still better than the existing system. Actually, Ripple specifically cited that some institutions wanted their payments to go slower. So look, I don't think speed is necessarily the issue. Ripple could just make ODL take longer. It's not like that would be like a game changer. They could have their fast on-demand liquidity and their slow, expensive on-demand liquidity with Bitcoin. Look, if you can't see why ODL can be used with any digital asset, then I just don't think you understand the product that well. Obviously, XRP is the best one to do it with, but almost any you could run ODL with Dogecoin if you wanted to. It's just liquidity. It's just liquidity. I think XRP is the best for it. So common sense tells you XRP will win out. The SEC delay undermines its claims. Yeah, I don't really care about any delay. Both parties have delayed this case a little bit. The SEC points to no further information that ODL buyers are required to protect themselves. The SEC fails to show any institutional buyers suffered any. Okay, so this is the part we haven't seen yet, and this is what we are waiting to see. This is what we've been waiting to see. The SEC fails to show any institutional buyers suffered any pecuniary losses because Ripple did not register. Its arguments are particularly weak as to the ODL sales. As a class, ODL buyers are sophisticated institutions who are able to negotiate for contracts, rights, disclosures, and protect their interests. They have contractual protections from losses and no right to gains caused by XRP short-term volatility. Indeed, they are exposed to changes in the price of XRP for mere moments when the cross-border transaction settles. Even if the securities laws require Ripple to prevent the information that the SEC suggests, such as financial statements, disclosures, and past given non-XCL buyers, the information would not help ODL buyers. Okay, long-winded way of saying that, look, the SEC is not protecting anyone here, and whatever the SEC is going to be trying to claim here in terms of ODL isn't going to make any difference because ODL has nothing to do with investing, and securities law is all about whether or not you're trying to make a profit. So, look, it's very clear to me Ripple's trying to get the court to say pretty much ODL is all set. So, guys, I think we have kind of Ripple's main arguments here so far. Shout out to Chad. Shout out to Chad. So we have Ripple's main arguments, right? Ripple's not selling in the United States. We predicted this one. 2, Ripple is changing the way they're selling to be more compliant with institutions. We didn't know how Ripple was going to do this. We were kind of guessing how Ripple was going to go about doing this. Our guess was that Ripple would just do whatever the SEC said they couldn't. I mean, do whatever the court said they could and just stay away from things the court said they couldn't do. This is exactly what they're doing. And then the last thing is obviously that Ripple didn't allow investors to lose money. Yep, Sean, you're 100% right. Sean was making this very clear to me. He said, if there's no losses, right, then no one is at damage, and therefore there's no investors to protect, or there's no losers, and therefore there's no disgorgement. So, look, when you assemble these 3 facts, it's looking very, very bad for the SEC. Very bad. I'm gonna check X real quick and see if anyone's picking up on anything I'm not. I know Sherry normally looks at some stuff. Let me just see her account real quick. Yep, Ripple only wants 10 million. Okay, here we go. Okay, so one of the big ones is going to be on page 18. So let's go to page 18 and see what we can get there. Yep, this one right here. Sean, you're going to like this one. You're going to like this one, Sean. Ripple's institutional sales caused no pecuniary harm. A Gobble defendants had told investors that proceeds from securities offerings would be used for corporate purposes. That representation was fraudulent because Gobble knowingly misappropriated the money, but the investors received return investment compensated on outset. There is no finding that that they suffered pecuniary harm. Accordingly, the Second Circuit vacated the SEC's disgorgement award and remained at the institution to make factual determination as to its pecuniary harm. Gobble's logic applies here even more strongly. Ripple committed no fraud. It made no pre-compliant institutional sales to 41 buyers. After years of investigation and more years of discovery, the SEC does not and cannot point to any institutional buyer that lost money as a result of purchasing XRP. Instead, those buyers received the benefit of their bargain, or any disgorgement for them was containing a windfall. I don't know what that means. This should be the end of the agency's request. Okay, so right here, the most important thing is this sentence. After years of investigation and more years of discovery, the SEC is not and cannot point to any institutional buyer that lost money on XRP. So, Sean, this is exactly what you were saying. The SEC can't find anyone who lost money on XRP. This is the argument we knew Ripple was going to make at some point, because law says that the SEC needs to find someone who lost money. The SEC can't do that. They're saying tend to make the SEC bite Hail Mary. I guess we'll officially wait for the start once the SEC files their SIR reply. Yeah, it's going to be really interesting to see what the SEC says to this. The SEC's response to this is going to be gold. It's going to be gold. I cannot wait to see how the SEC is going to try to argue this. It's going to be funny. It's going to be funny. We're expecting their reply in 2 weeks from today. 2 weeks from today, we get the SEC's reply. Guys, if you're on X, make sure to drop a retweet, and if you're on YouTube, make sure to like the stream. Really, really helpful. The SEC. Let's see. Oh, sorry. I think Sherry said something else you need to take a look at. Page 30. Okay, that's just what Ripple wants to pay. Okay, so the end of this is just talking about Ripple only wants 10 million. Ripple's just going through other cases in which Ripple cites a whole bunch of other court cases in which they say, look, no other crypto case has ever gotten close to 2 billion, so it's not going to be more than 10 million. Or Ripple doesn't want it to be more than 10 million. I think it'll probably be maybe close to 20 million to 30 million if I was to guess. 100 million max. Okay, Ed's got it. Sorry, Fred's got it. Let's go to this. This is what we were looking for. It's time for me to delegate my responsibilities to a professional. I think we did get some pretty good breakdown. We're gonna go through what Attorney Fred had to say here. I will say what we have learned so far is two things that I believe were obvious. Right, most of Ripple's sales are outside the United States. Two, Ripple's contracts with institutional investors didn't cause any harm. Most people are still profitable on their XRP. So those are the two obvious ones. The one that I think is really promising, and one of the things I was worried about, was how Ripple was going to structure ODL in the future. And this is something I've been speculating on, but it's absolutely amazing. It's absolutely amazing to hear Ripple say it. Ripple's just saying, look, we're doing ODL differently, and we're doing it in compliant with the court's ruling. This lets me know that, one, Ripple's going to be able to, in the future, keep selling XRP to these financial institutions and not be in a position where they're actually violating any rules. And two, that they're not looking to appeal anything. Ripple's saying, look, we're perfectly fine going forward with the court's decision. We don't have to change anything. We're just going to do this in a compliant manner. So the two things that I've learned from today's ruling so far, without jumping into any other lawyer's take, is one, that Ripple's ODL business is still 100% possible. And two, Ripple doesn't have to appeal anything for them to still be compliant in the United States. So I think those are the two big things I would take away from what I'm reading so far. I think a lot of this stuff was really expected. I think in the beginning, Ripple really hit hard. They made some really good statements that are really going to ring home to the judge. I think the best statement there was that the SEC needs to prove that Ripple is reckless. The SEC didn't even allege Ripple was reckless. The SEC needs to prove that essentially Ripple committed fraud. The only people that the SEC charged with fraud were Brad and Chris, and the SEC realized that those charges were so weak, they ended up having to drop the case. Let's go. Let's get into what Attorney Fred said. Ed said not settling. Yeah, I don't know. I don't see the settlement either, Fred. They're crushing the SEC. Let's see. Attorney Fred says, here is my hot take on Ripple's opposition to remedies. Too long to read. This is that anything greater than $10 million would be totally unfair and inappropriate. Ripple is in a great position to win this one, but they are unfortunately ominous signs. First, as predicted, Ripple has changed its operations to account for the court ruling. It has kept all its major ODL offshore, mainly in Singapore. Judge Torres, in my opinion, will not get into a factual fight on incomplete record, so Ripple wins because the SEC can't carry its burden. Interestingly, sadly for us, for US ODL, we have confirmation why Ripple decided to issue a stablecoin to allow US-based compliant to use ODL but not XRP. Also great to see Ripple shove it in the SEC statement about losing in its face. Okay, so I don't know if I agree with Fred here. He thinks that Ripple stablecoin will be the replacement for XRP in the United States. We'll have to see about that. I don't know about that. It's lengthy. In Exhibit A is a lengthy declaration from Monica Long that reveals some interesting business practices, like stopping institutional sales in 2019. Ripple is aiming for a money transmitter license, 45 states, and changing ODL contracts. Lots more to dive in here, and I still need to. Bad news, the parties are teeing up or posturing on round two. Ripple tells court if the SEC wants to sue on new contracts, it needs to bring new enforcement action. SEC getting hammered with a low penalty will help in dissuading a repeat enforcement action. I don't know what's bad news there. Apparently, Ripple's tempting the SEC to go back at them The SEC getting hammered with low penalty will help dissuading them to repeat offense. Ripple did throw in the debt box case. Not that he says it's not that important to have the debt box case in there, but since the SEC was putting mean tweets in there, it's good that Ripple did it. The numbers of characters redacted on page 23 are 11 or 12, meaning less than 9 million at most. This is where Ripple got his 10 million number from. The SEC has a goal to ask for 2 billion when it's only sanctions its boys a couple milli. Not going to persuade Judge Torres. Oops, something forgot to redact email addresses. Kindly refrain from contacting. Okay. Wow. So Fred's prediction is Ripple pays less than 25 million. Guys, this is even better than what I thought. I mean, I thought Ripple was going to pay close to 100 million. It looks like Fred is saying that it's likely that Ripple is going to pay less than 25 million. All right. Unfortunately, that guy had to get FE for life, had to get put in a timeout. Did Deaton say something? Less than 25 million. That would be horrendous for the SEC. To be honest, big fan of Attorney Fred. I don't know if I really got anything new here from reading through. The one point he made that I kind of disagreed with was Ripple's using the stablecoin for ODL. I don't think so. I think Ripple's going to keep using XRP for ODL. You're good, Silver Days. You're good. XRP fudsters in full panic. Unfortunately, there are some. Yeah, I don't know. Let me see if we get any other. Did John Deaton comment? John Deaton. Let's see if John Deaton commented. Oh, I don't want John Deaton's Senate account. I do want you guys to all go vote for John Deaton, but you want John Deaton's main account. Yeah, no comment from John Deaton yet. Sherry normally has some comments. We'll check through Sherry real quick. Okay, so all we're getting from Sherry here is just kind of an outline for how long things would take if they did go to the Supreme Court. She says 12 to 14 months for the appellate court. So that would be the next circuit would take 12 to 14 months. And then after that, you'd have another year to get to the Supreme Court. No one knows if we're going to go there, but it's useful information nonetheless. Let's see. So Ripple's literally saying they're willing to pay 10 million. So between 50 and 10 million, I think. 50 and 10 million will probably be what the lawyers or what they end up getting hit with. Yeah, I wouldn't count on it going to the Supreme Court. It's possible, but I don't think it will go there. I think 10 million is more than fair. The SEC should settle and move on. This is not getting any better for them or Gensler. Yep, I agree. The SEC should settle, but I don't know if they will. I think this has been more of an attack on Ripple, and they want to keep attacking Ripple. Metal Law Man is getting in on the action. Big fan of Metal Law Man, guys. If you don't follow Metal Law Man, I highly suggest you do that. Some of you don't know this, but Metal Law Man is actually fighting a case right now on behalf of XRP holders. Metal Law Man filed a case essentially against New York, a New York policy making board, I guess, that took XRP off their list of investable digital currencies. And Metal Law Man is actually suing to figure out what happened there. So kind of a hidden hero of the XRP community. This guy's really sharp. He's a really good speaker. Really love listening to his opinions. He's going to be at XRP Vegas too, so he's committed to the XRP community. If you guys don't follow Metal Law Man, I highly suggest you do that. He's a great follow. Great follow. Dirtnap, this is a sentiment I kind of want to make a comment on. Look, I understand people don't want Ripple to settle because they just want to see Ripple pummel the SEC. The only problem is that means this case can be appealed, and I would just rather have this case be over with forever, never have to think about it again. So as much as I would like to see Ripple win outright, I would also like to see this case be over. Oh. Firedog, can the SEC name one institution that lost anywhere close to part of the 900 million? Have they? No, actually, Firedog, that's actually one of the things that James K. That's actually one of the things that Metal Law Man has made so clear here. The institution didn't name the SEC didn't name a single institution that lost money on XRP. That was one of the things they were required to do. They failed to do that. So the SEC completely whiffed on that, and they had to present a new theory to the court, making up why they think Ripple should have to pay not 900 million, 2 billion. It's better for XRP to settle so the SEC can't appeal. This is the logic I take, Brian. This is the logic I take. Unfortunately, I think that is the case, but I understand why people just want to see the SEC lose at this point too. I was disappointed to hear that John Deaton actually really isn't being Warren. He gave himself 1 million, so actually Warren outraised him by 3x. And it also depends on what Warren gave herself, right? Uh, 33 million paid in XRP. That'd be funny. Let's see what James K. Filan says. I mean, Metal Law Man says. Sorry, guys. A little tired here, I guess. As we anticipated, Ripple argues no victims, no disgorgement, relying on a Second Circuit case I discussed with Scott Melker in the clip below. Ripple money quote, after years of investigation and more years of discovery, the SEC does not and cannot point to any institutional buyer that lost money as a result of purchasing XRP and Ripple. All right, this is actually something that we highlighted when we were reading through the brief. So I'm going to post this comment in the chat. This is a big one, and I'm just gonna. There we go. This is a big one. Yeah, it's all right. It's all right. I understand some people really like to be right. I just want you guys to realize you can totally use ODL with Bitcoin. It doesn't work as well. Like, it works much slower and much less efficient, but you can still do it. Legal question. If Ripple does not settle and wins, is there a time limit for the SEC to appeal? Sean, that's a great question. I don't think so. I think the SEC can appeal whenever they want. I don't think there's a time limit. If there was, that would be really bullish, because say it was like 6 months and the SEC had to wait until Gary Gensler was out, that would be outstanding. I don't know though. I'm convinced Ripple knows what's going on here. I'm really not too worried about it. It seems like the SEC is settling the whole thing for an appeal to stall it all. They won't settle knowing it's going to be 50 million at the end of the course. Yeah, I don't know. We'll have to see. I think John Deaton's going to do a class action, Ed. I think he just needs more information. I think he needs more evidence, more to come at the SEC with. Do I ever sleep? I need sleep. All right, guys. I think we actually covered most of it already. I think we got through all the important stuff. I know we didn't go through the whole document, but I was going through with I was going through what all the lawyers said, and it seems like we nailed it. Seems like we nailed it. Why is XRP so huge in Korea? I don't know, Salamander. I wish I could. I wish I could give you a better answer than that. I don't know. I really don't. Maybe they're just smarter in Korea. Maybe in America we're all obsessed with Solana. It's a broken blockchain. In Korea, it's a bunch of little geniuses running around, knowing that the XRP ledger is the best blockchain out there. Obviously, I'm just joking there. I don't have a good answer for you though, unfortunately. If Ripple settles, they will receive a no action letter. No, it's you just can't. Once you settle, you can't appeal because it means the case is you can't appeal a settlement. An appeal ends it outright. I mean, a settlement ends it outright. An appeal would mean that essentially you're going against what the court ruled. The court didn't rule anything in the settlement. I'm going to have my friend ask some of his students who are into it. Into what, Harley? Oh, 604 likes. That's absolutely amazing. When I'm over here on StreamYard, I can't actually see the likes on the stream. So that's incredible. That's really cool to see. Let me see. Oh, yep, 608. Wow, that's absolutely massive. You guys are killing it. Thank you guys so much. You guys are absolutely amazing. Oh, he's a teacher in Korea. Oh, very cool. Very cool. Yeah, Harley, let us know on a future live stream when you get an answer. Those are the kinds of things that I love to hear about, man. That information that I can't get from X or any kind of like on the ground information. I love that. All right, guys. So I'm going to do a recap here. Great filing by Ripple. I think the first couple lines were kind of the zingers of it. I think that's kind of where Ripple came out swinging a bit. Really wanted to shove it in the SEC's face. It's just right here. The remedies in this case should reflect its facts. Ripple is a 12-year-old financial technology company that has played a key role in developing innovative technologies that use the open source XRP Ledger blockchain. Its on-demand liquidity service generates real-world value by making cross-border payments faster, more transparent, and more cost-effective. This court has ruled that Ripple violated Section 5 of the Securities Act, a strict liability statute, by offering certain sophisticated investors investment contracts related to the digital asset XRP. Ripple has publicly acknowledged that the ruling and does so again now. It has changed the way it sells XRP and changed its contracts to avoid the problems identified by this court. It has ensured that its counterparties are qualified as institutional investors, accredited investors, and its subsidiaries have obtained license to sell XRP, a digital currency, outside the United States under the supervisions of regulators who do not treat XRP sales as sales of securities. Those appropriate responses to this court's ruling provide reasonable assurance that these violations will not occur in the future. The SEC's remedial requests are more evidence that the administration of the administrative overreach that has beset this case. The agency acts as though it had prevailed entirely and had proved reckless conduct. It has done neither. The court ruled that most of Ripple's pre-compliant XRP sales were lawful. When it brought this action, the SEC did not even allege that Ripple itself acted recklessly. It did make such allegations against Ripple's chairman and CEO, but abandoned any attempt to prove them to any fact finder. Yet the agency now urges the court to find Ripple reckless as a at the penalty stage and to issue an injunction based on mere speculation that Ripple may break the law again in the future. The agency also seeks disgorgement barred by controlling Supreme Court and circuit precedent, and a separate penalty that exceeds more than 20 times what what it has obtained from any other defendant or respondent in a digital asset case. This court's ruling has provided welcome clarity and guidance about the ways in which Ripple can lawfully distribute XRP. Ripple has every intent in adhering to the guidance in the future and every incentive to do so. The SEC's draconian remedial requests are ungrounded in law and principle. This court should reject them in their entirety. So I think that pretty much sums it up here. I think that's the most important thing. Ripple goes through the rest of the document and really jumps into the nitty gritty of it all. At the end of the day, Ripple's selling ODL in a way that's compliant. They're using XRP in ways that don't violate what this court case said Ripple's not allowed to do. Ripple is selling outside the United States. Ripple is selling to only institutions. Ripple is not selling to institutions in a way they can profit. So... Oh, okay. This is exciting, guys. This is exciting. Let me see. I got some big news. I got some big news for you. This is exciting. Well, let me see if I can find it. James K. Metal Lawman says 60 to 90 days after May 6th, we should be seeing the decision. We should be seeing Judge Torres rule. So 60 to 90 days. This is exactly what we've been talking about on the channel. This was the time frame I was given. This puts us at middle to late summer, maybe even early summer. Let's see, May 6th. What is 60 days from May 6th? 60 days from May 6th is 1 month. So between July and August-ish, yeah. July and August, I think, is a conservative timeline.